Welcome to the Insurance Lab, gentlemen.
Good to be here, Ben.
Yeah, it's nice. Mike, I've known you for a long time. I feel like I've known you for pretty much most of my career at Heffernan. We were young insurance brokers many years ago, and now we're old and gray, and we've got kids in college.
I remember calling on you when you were sharing an office with a bunch of folks, and it has felt that way. Yeah, I had one kid when we met, now I have three.
Yeah, it's amazing how that happens. Yeah. Anthony, nice to meet you. We don't know each other as well, but I'm super excited about having you here on the podcast because we're going to talk about a subject that is important to Mike, important to me, important to our clients, and that subject is habitability claims. You are a specialist.
Thank you for having me. I'm glad to be here.
Yeah. Anthony, I'll kick it over to you. Tell the listeners a little bit about you, your background, and what you do, and specifically on habitability claims.
Thank you. I'm Anthony Marinaccio. My law firm is Marinaccio Law. We're located here in Glendale. We mostly represent landlords with regards to landlord-tenant issues, including evictions, habitability claims, and contracts. A lot of the issues that we deal with habitability include lawsuits that tenants file against landlords, either current tenants or past tenants, regarding either habitability, wrongful evictions, breaches of rent control laws, but in particular habitability claims.
Yeah. So, how would you define for the listeners, what is a habitability claim?
Habitability in California, every landlord-tenant agreement for a residence has what's known as an implied right of habitability, meaning that the property has to be in certain condition. It has to be habitable. And I'm using the word to define the word, but it has to be proper to live in. For example, it has to have heat. It has to have walls that don't have holes in them, free from pests, plumbing that works, that isn't leaking or that isn't defective, electrical that isn't defective, windows that operate. That's kind of the statewide rules. And then in addition, we have some local rules that also would apply that sometimes involve rent increases or the types of evictions that you can pursue.
So a tenant then could pursue legally for legal recourse against the apartment owner, right, for allegations of wrongdoing.
That is right. If a tenant believes that the landlord hasn't fulfilled those obligations, and in addition, we also see a lot of claims. For example, there's also what's known as a breach of quiet enjoyment, meaning that a tenant is allowed to have quiet enjoyment, be able to enjoy their house without the bother of neighbors or without the bother of their landlord. So what we often see is claims later on where tenants are alleging that landlords are harassing them, showing up at all hours of the night or day, arguing with them. But yes, generally you can have a claim. A tenant can make a claim if they believe that there haven't been repairs made to a unit that should have been made, particularly if you have a health department or a local housing department that's gotten involved, that maybe they've told a landlord to fix things and they still haven't fixed them, things like that.
Okay, so Mike Freeman, tell the viewers a little bit about yourself and what do the carriers think of these things?
Yeah, so Mike Freeman, I'm with Philadelphia Insurance Companies. I've been at this at my spot for 19 years, as we mentioned and we talked about, And as an insurance company, what we do, our job, of course, is to indemnify our policyholders, and it's to make them whole, so to speak, and it's to defend them from lawsuits. And we as a company, we have some specialties. One of which is in the housing areas, whether it be our specialty in that area tends to focus on nonprofit affordable housing. We also do some market rate housing, and just talking to this point in particular, I think it's something worth noting, which is I think the intent of any law is usually good in a sense. I think it's a great thing that you should not have a house with mold in it, with bed bugs that no one addresses, with leaky plumbing, and you should be able to, if you're paying rent, be able to have your electricity fixed. Absolutely, I think that's completely reasonable. And I think what we tend to see with any law, and I can harken back to, ADA lawsuits, right? Where the intent is that someone with a wheelchair is able to access your business, right? And what it turned into is someone can drive by your business doesn't go in there, doesn't try to go in there, but notices you don't have a ramp, and boom, they can file a lawsuit.
Right.
This is a bit different, but it's in the similar vein where it's essentially becoming industrialized, these lawsuits, where it's, the intent was, let's make sure people don't live in a slum that is essentially unlivable, uninhabitable, right? We want that.
Right. I mean, look, we could have a conversation on the weaponization of lawsuits outside of this as well, right?
Yes.
We just drove here on the freeway. How many signs did we pass, of attorneys that are, did you get hurt at work? Did you, get hurt in a shopping mall? Where did you get hurt? We can get money for you. And, everybody thinks it's a lottery ticket, right? It's interesting that these habitability claims seem to have popped up really on the carrier's radar within the last couple years. It used to be, Anthony, we would place covered general liability policies, and habitability, we wouldn't even think about it. There was no sublimits. We wouldn't even question or read the verbiage around the habitability claims. And I'd say maybe about 2-3 years ago, it started, bubbling to the surface. Are you finding that the intent of the law was altruistic, but attorneys are now finding that it can be weaponized and using it as a business? Anthony, you're shaking your head too.
Yes, it can be, because I think what happened is the laws habitability laws have been around for at least 50 years off the top of my head. It's not like these are just new laws that just came into a place, but what's happening is that they're becoming more common. I think I see a lot of them in reaction to eviction lawsuits, that a tenant gets evicted for one reason and then believes they should be compensated for that. And then generally they find some habitability claims, but they seem to have ballooned ever since the pandemic. They have ballooned.
Right.
They're everywhere.
I would say to that, though, too, like, we've been seeing these suits for longer than that, right? Maybe going back 10 years. And I did a little research, and I would say about 10 years is when we saw the first suits. And it also, at the moment at least, appears to be a California phenomenon.
I was going to ask on this. This is primarily a California issue. Or is it nationwide?
Like many things, but we can't expect it to remain only California.
Right, we're ground zero for now.
Yeah, exactly. Like everything, it'll eventually spread west or east. Excuse me, but it's not a brand new phenomenon. It definitely has ballooned, I would say. And one thing that's interesting, of course, is the way insurance companies work and structure policies is occurrence-based for the most part, right? We've all written commercial general liability policies with standard ISO language going back. And so in occurrence form, anything that occurred during that period could be covered. So what we're seeing is these lawsuits the attorneys are intelligent, they're smart people. They're not going to sue one policy year one time. They're going to go back and grab as many of them as they can. And that tends to be what we're seeing. So now you're seeing 5 insurance companies involved in one class action.
Right, and the larger the complex, right, the more opportunity there is for class action.
Yes, and there probably are. Now there's I would assume a mix, right? There's probably some very legitimate ones, and there's probably some that are not. But the lawsuits are written in such a way that you can't simply dismiss them. They're going to have to go through a process. So that creates its own problem for the insured.
Right.
Ultimately.
So when we're thinking about multifamily, right, you have apartments, and we can break down apartments, market rate, affordable. You technically throw student housing in there as well. Mm-hmm. Are you seeing more of these claims on affordable, market rate, equal?
Yeah, it's a tough question to answer. I will say the biggest, most prolific claims that we were on a very large for-profit individual. But we, as an insurance carrier, if you look at what we write more of, it's more nonprofit affordable housing. So we absolutely have more in the affordable side. So I can only answer from my perspective. If you were to look at the universe of these suits, I think that for-profit guys are getting them more often. Nonprofits, what they tend to do, I mean, there's very strict covenants actually on how they're to keep these properties up when you're talking about dealing with a large or any size affordable housing provider. It's essentially more strict in a sense than a market rate property would be, which means they're investing more in maintenance and keeping things up. So we do have, I think, a better platform to defend from many times. So the answer to your question, I guess, is I can only answer from my perspective, which is we're seeing more of them on the nonprofits because that's who more
right, because your data set's more leaning towards the nonprofits,
but we definitely have seen them on the for-profits as well, and the ones that we don't write as much of it anymore. We reduced our volume in that class by quite a bit, but we still are seeing suits coming back from policies we had maybe in 2016, 17, that kind of thing.
Right. I don't know if you have this data. Is it, generally like urban corridor? Is it, in the countryside, in Northern California, Southern California? Can you break it down that?
Yeah. I don't have the exact data, but I actually explored that exact question, and there's a couple things that drive it. The number one thing that seems to drive this, and maybe they just go together, is urban/venue, right? When we look at big picture, where do we not want to get sued? Really,
right.
Where do we really, really, really not want to get sued? That's where we get the lawsuits, right? The very tough venues, which guess what? They happen to be urban, right?
Correct on this one.
So, yeah, whether it's, you're talking about Los Angeles, you're talking about Alameda County or San Francisco, being the big ones. That's where we've seen most of the suits.
Right. And Anthony, I'm going to come back to you too and your perspective on this one as well. With Mike, from an underwriting standpoint, then you have to factor that in, right? Where's the location when you're looking at a risk, not just the loss runs, but the jurisdiction?
Yeah. And we do look at jurisdiction. We don't look at it. What I wouldn't say is that we specifically underwrite for habitability lawsuits, because I don't think that we do, but they go hand in hand with having a higher quality operation, a higher quality product, so to speak. The better it is, the less likely you are to get into these suits, but that does not protect you. And it also does not mean that we haven't got suits on some fantastic operators, because we have.
Right.
People that I would call best in class, that I know are best in class because I've visited them, I've been there, and I've walked the properties. I know the people that run it, and I know they're best in class, and yet we still do get suits at times.
Right. That's interesting as well, too, because you're not only underwriting the loss history, but you're also underwriting the management company and the owners, right, as much as the losses.
Yeah, and without going sort of like off script in a sense, but what we do underwrite that, absolutely, and where we look at some of the questions that we're starting to ask around it. How is your turnover for your property management team? That's a big deal.
There's a correlation between turnover and
100%,
and have
right?
claims.
We see that. It's not even necessarily that chicken or the egg, I don't know, but when we see high turnover and there's a suit, and maybe there's high turnover and then there's a suit, right? Maybe one follows the other. I don't know which, but what we tend to see is it's harder to keep really good records and logs and documentation, because and he's, I'm sure, going to say, and I don't want to steal your thunder, of course, but I'm going to, I guess. But documentation is the really only thing you have. Right. So every time somebody calls, a tenant calls, hey, my water's out, or hey, this or that or the other, there has to be a corresponding
I totally get that.
When you have turnover, you lose some of that. Some of that just disappears into the ether.
Right, because they lose that that intellectual capital of knowing how to handle it. Somebody new comes in. Anthony, I'm going to kick this over to you right now, because I was going to ask you, look, if you were teaching a class to landlords, right, of best practices in this area, where do you start?
Documentation.
There you go.
I think that's what he said. It's all about documents. It's all about, if there's a repair request, it's documented what was done, when it was done, when the complaint was given. Documentation, because a lot of mom and pop landlords, and I know we've talked about a lot more institutional, but a lot of the mom and pop landlords that I see tend to have, that's their issue, is it tends to not have a lot of documents. And documents can be anything. It can be text messages, emails. It can be. It doesn't have to be an actual book of like a log or something. But a lot of times there's nothing. There's very little communication between anyone. And then later on, when someone says or is claiming, I told you that there was mold 2 years ago and no one did anything. Well, now there's nothing to show that. There's no photographs. There's no photographs of the unit, what it looked like perhaps when they moved in. Or while they lived there. There's sometimes some landlords don't keep copies of the inspection reports that came in from the city or the county. That's where some of the biggest issues come in.
Right.
Is, text messages, emails. There's just a lack of them.
Well, let me walk you through an exercise, both of you, on this one. Okay, let's say I own a market rate complex. It's I live in the South Bay, and the property manager or the landlord gets a phone call. Hey, this is Ben from Unit 301. I have water damage, in my and mold, or should I say mold in my bathroom. I need somebody to look at it, right? I'm concerned. Talk me through the process. I get that phone call. Then what? What does the documentation look like? What do I do?
The best way would be photographs of what it looks like when the incident occurred, the repairs when they're done. Things have to be done in a manner that is reasonable, and I know that that's hard to pin down because it depends on how much damage there is, what has to get done. Oftentimes, you're going to have issues with the tenant not wanting to vacate or not allowing contractors, which becomes a big problem for what we do. That's a big area. They don't allow entry, and then there should be documents as to that. Where for example, I as a landlord, they told tenant be available on Monday. We're going to start work, and then Sunday night they say I'm not going to let you in. There has to be some sort of document that says.
So that's a defensible position.
Yeah,
we tried to remedy the situation, but we weren't able to get into the apartment. And here's the documentation. This day, right?
Yeah, that's actually one of the best defenses is that the tenant did not allow you in, or was actually being combative about it.
So on the documentation, you can go as deep as talking about the tenants, the way that they were responding.
Correct. I mean, or
combative.
Or you just see the text messages themselves, because a lot of the mom and pop landlords, they are going to be all by text message or email, and you see it. They just the back and forth. It's also important, though, when I say that, also that everything can be copied and everything can be, shown to someone else later. So sometimes the tone, even on the landlord side, has to be not combative, because you just want it to look like if this is what's happening, just so that there's an easy timeline.
Matter of fact, keep emotion out of it.
Correct.
Right? This is business.
90% of the cases, especially on the mom and pop side that I see, 90% of the cases are emotional. They are not. Generally, what happened is emotion took over, arguments started, and then things kind of came out of control.
Interesting. So if you have a property manager that works for you, number one, you'd say document when the call came in.
Correct.
Number two, what's a reasonable amount of time to respond to that initial call?
It's a good question. I would say as soon as possible, meaning that, for example, if it's a large water issue, I mean, if it takes a few days to get the contractor there to do the work, that's one thing. But if it's things, a lot of the issues that I see probably could have been addressed very easily early on if they had just been addressed early on, as opposed to letting things go. For example, a leak, that maybe there was a complaint about a leak from upstairs to downstairs or or plumbing that just wasn't addressed, and now it became worse, and then a few weeks later it got worse, and now it's a big problem. Small problems can be addressed easily. It's the big problems that sometimes take a little extra time. Sometimes if there's an insurance claim, that sometimes adds a little extra time, as long as it's reasonable. And reasonable, I know it's hard to describe, but it really depends on the availability of contractors, the holidays. If something occurred on a Saturday night, no one is expected, unless it's a major problem, to fix it on Sunday morning, but it has to be done. It has to be done eventually.
I think one point I would add to that, or at least enhance maybe, is when you get that call, and around mold specifically, what we've seen a lot of that's hurt us in our cases is, did they repair it or mitigate it up to the highest professional standards, right? I mean, we've seen this. Oh, they went in, they wiped it off with a sponge, like that kind of thing. That's not going to work.
Right.
Ultimately, right.
So you could do everything right, but you don't make the repairs the right way, and you're in a hard position to defend.
And a lot of times it's it's just it's a maintenance guy who's there. Oh, I'll paint over it. I'll scrape, but whatever it might be. That doesn't mitigate the mold, and that's not completing the repair to the highest professional standards. So that's something. like the documentation you mentioned, I think you cover that, pictures before and after, et cetera. That's great. Make sure you can demonstrate that you handled the mold. And I think the mold is interesting because it's it becomes a little bit of a gray area in coverage in terms of how coverage responds for the insured's behalf.
Right. Because now that's excluded. Bodily injury because of mold is an excluded BI on almost all GL forms.
Right.
Gets picked up under the pollution policy.
If they have that.
Right.
And it can be defensible. In other words, we may have to defend that claim, but it's not indemnifiable. So we're not going to pay the judgment, and the judgment at the end is going to include plaintiff's attorney fees.
Right. Well, that's an interesting point. So if you send your employee to go in and make those repairs, do you trigger potentially coverage under the GL as product completed ops?
Well, you essentially trigger defense, but whether or not someone goes there or not,
right?
Yeah,
that's on the BI as opposed to
it's just we're not gonna, this is, you've seen these as well. You're not gonna get a complaint that lists one thing.
Yes,
right?
that's true.
It's
Everything gets thrown
50 things.
Correct.
Mold could be the thing though that's the biggest problem in there, and that means we're gonna defend it the whole way. But maybe we'll not. Maybe the payment for the end damages isn't there. So it does become it becomes tricky. These are complex cases, and you're talking, I think, mainly more like onesies and twosies in terms of plaintiffs. Where I see them and where it hits my radar would be 30 plaintiffs and up, and those can add up, right? Those become big dollars,
right? So on those instances where you have it's 30 plaintiffs, there's 30 times the opportunity of making a mistake. Right, like you're pulling all of the orders and the complaints, and you're looking at it in total. And if you have 15, 20 of these that you didn't respond to fast enough, that's just not going to look good.
And a lot of it is trying to disprove. You can't disprove a negative, so to speak. They're going to say something happened, and maybe it did, or maybe it didn't. But you have to essentially almost prove it didn't happen, if that makes any sense. But it becomes very difficult to defend, and they're exhausting. And the cost on them, we sort of have our own internal cost of what we think it costs per plaintiff.
Right.
And they're not going down.
Yeah. So, we've all kind of lived in some places that were questionable.
I went to college, so yeah.
You were college in Northern California, and I lived in New York right after I graduated, and I lived in some places in New Jersey that were questionable, to say the least. And so I'm thinking about some of the stuff that I've seen, infestations, right? Bed bugs, right? Next to mold, what do you think are the claims you see most common?
Mold is number one allegation. Bed bugs is there as well. So it's a lot to do with water, like anything, water damage, water intrusion, which obviously begets mold as well. That's the number one cause of action that we see, is generally stemming from water. After that, I think it'd be bed bugs actually would probably be the next thing on there. Very hard to really eliminate bed bugs in a building once they're there. It's just you can go and treat a unit, and they're back in that other unit before you finish the building.
Right. Well, if any of us
your best efforts may not work.
Yeah.
I guess is my
if
point.
you have kids and they come back from camp, that was like one of the worst things. You had to make sure that you washed the sleeping bags before they brought them into the house.
Yeah. It's those are probably the two most common. There's a lot. These are various and different and take many different shapes.
What's one of the largest suits that you've seen? Or complicated.
Seven figures, and it's I'm briefly alluded to it, and I obviously am not going to give the name of anyone or insured, but we had a one individual insured that ended up attracting these suits, and I'd have to tell you they probably did deserve a lot of it, frankly. But once blood is in the water,
right?
This property owner has been hit a few times. Yeah, the sharks are going to circle. The plaintiff's attorneys. There's really, it started with a few firms that really were specializing in this. And they're smart people. They essentially have salespeople that are out on the street looking for future clients. So, they hear about a big entity with, 10,000 units that's got a reputation, they're going to, believe me, they're showing up at every single location.
Your success makes you more of a target.
Walking around with a sign-up sheet.
Right.
Yeah.
Right.
100%.
Especially if they find out there was an issue, that they are having issues with repairs. Right. Then they start going around. Every tenant's going to get a postcard. They're going to get mailings. They're going to get knocks on the door to be involved in another lawsuit or this lawsuit, and that's when things can just avalanche.
Yeah, the answer really is not like one individual suit. That was the biggest one. It's just that one individual client that had, I mean, we're talking dozens of individual, not individual tenants, right? Dozens of individual class actions brought, right? By 50 tenants at one location and 70 at another, et cetera, et cetera, et cetera. So that was pretty significant.
What do these solicitations look like? I mean, what's on a typical postcard or letter or phone call into a tenant? What are they saying?
It's hard. I don't know the exact answer to that. You might know that better.
It would basically be, do you feel aggrieved, or do you feel like your landlord has been unjustly harassing you, for example? Call this number. That's basically
that. As simple as that.
Yeah, I mean, it's basically like kind of like the ad, kind of like the billboards you see all over LA for workers' compensation claims or for employee disputes. Same idea as that. Stuff like that. Like, you know, have you been hurt by your landlord? Why don't you call this number? Because they do come up a lot when you've sued one landlord and they find that there's been a big issue.
Right.
You might start getting other postcards to other tenants.
In some ways, they're fishing with a net, because they may say, like, I slipped and fell, or they may say that, I'm sick. I think there's mold in the walls, right?
A lot of times you see it. A lot of times you see it in LA, especially if you're doing, you had a few years ago when landlords were doing like mass buyouts, and they were doing evictions for like an entire building, and they used to band together to do something like that. Those were very common for a while, and then. But that's generally what you would get, something like that. Just like a solicitation is generally, call this number and see what we can do for you.
They will organize meetings on site. Like you'll have maybe in their rec room or whatever. They're trying to get as many tenants as they can to come down, sign up, be a member of the
That's
of the suit.
Wild. Yeah. They'll show up and say, it's almost like giving a speech on a topic, and they're just hoping that somebody finds this the interesting topic to listen to. Yeah. Interesting on this one. We see claims hit when economy kind of goes down, goes up, employment goes down, goes up. I mean, is that fair to say on these types of claims too?
I would say it's fair to say.
Yeah.
Because I think.
Yeah, it's been the last 10 years and the economy's been not bad.
We've been at full employment.
Yeah, I don't know exactly how it correlates. The main impetus for these suits is absolutely the plaintiff's attorney fees, right? I mean, they're generating attorney fees. That's the main impetus there. So, you just have attorneys, they move from one thing to the next sometimes, and you can build a phenomenal career there, right?
Yes.
I mean, wage and hour is a really easy corollary, right? Those became, some of those guys retired after 3 years of handling a couple of big suits because boom, you won one or two and you're done, right? These aren't quite that. They're smaller ticket compared to a $200 million class action settlement on McDonald's or something like that. But it's a way for to generate plaintiffs' attorney fees, essentially, and it's a pretty good one for them, I think.
So let's say, okay, so let's walk through this scenario. I own a building. I get a summons. I get a phone call from an attorney where you're going to get sued. What do you do? What's the first step, Anthony? What do you think?
The first step would hopefully to make a claim to your insurance company. That's the first step.
If you have the coverage.
If you have,
we'll talk about this too.
Right, and they'll sometimes tell you one way or the other, but that's the first step.
Right.
Generally, if you've been served with a complaint, you have 30 days to respond. Ignoring it isn't going to make it go away, so just respond to it. But generally, the first step should be to file the claim if there's insurance. But I'm finding right now, especially, a lot of people don't have insurance. Either they don't have a mortgage on the property. Something like that.
Yeah, I mean,
I'm
actually
noticing that more and more, that people just did not pay for it. Something happened.
Right. Well, Mike, let's save this, because I do want to talk about sublimiting and excluding coverage on forms for the listeners. Right now, talking about what to do immediately. So, Anthony, you said get it to the insurance carrier. Correct. Agreed on that one. What should you start collecting? Start collecting all that evidence and start building a defensible position. Every
document associated with your tenant and probably the building at this point. you would want to get everything together because that's going to be the case. I mean, that's going to be your defense is everything that you possibly have, including, I said earlier, like pictures, text messages, emails, if the voicemails that you kept all over the time. Those are the most important things to keep. Probably maybe even to write down a log of stuff that you remembered, because sometimes the statute of limitations on most habitability claims is 2 years. Although I've noticed most of the time they do get filed pretty soon after an incident or the tenant has moved out. So that's when things are fresh, it's always better to remember things. Than lawsuits have a tendency to take a long time to move forward. So you could have a lawsuit that goes for 3-4 years. So what you don't want is to be asked 2 years after you've been served by your attorney, get me this stuff, and now you don't even remember what happened.
Right.
You don't even remember the tenant's name or something like that. And so what you want to do is try to keep everything together then. Don't destroy documents because that's going to make things much worse. So, but put everything together. That's usually the first step, get everything in there. For the most part, I see a lot of claims that the tenant has moved out already. So there's really nothing else you can do at that point because the tenant's not there. So the unit has probably been turned over, doesn't exist. I see a lot of claims also from tenants where the landlord has sold the building already. So then they really have nothing left to go to the property to take pictures or do anything. Because that statute of limitations is 2 years, it's you could sell the building in between. And because I also do see a lot of claims from what ends up happening is that the current owner was probably more aggressive than the old owner, and that caused the tenants to maybe file lawsuits, and then they include the old owner just because of the 2-year statute.
Right. When you mean aggressive, do you mean aggressive on collecting rents, or
particularly in city of LA, when you do have rent control tenants, they may be being aggressive to evict tenants to get them to pay market rate. When I say aggressive, I mean maybe trying to enforce lease provisions that were not enforced before, payment issues. Sometimes they're trying to go around doing buyouts and doing things like that put people on edge. I see a lot of those where they're suing the prior landlord, the one that sold the building already.
Right.
But yeah, the first thing is to get all the documents together. And you do need to make a claim or talk to an attorney because you do have a 30-day window to respond. If you don't, you get a default, and that's the last thing anyone would want. That only makes things worse. So if you want to make sure you respond to that lawsuit.
How many of these claims go to court? How many get settled out? What's your experience?
Almost all of them settle. We had talked about weaponizing, and the problem is similar to the wage and hour claims. All habitability claims have attorney's fees provisions, and oftentimes, I know some landlords think, but there's a lease provision that says that there's a cap. There's some law that goes both ways that says that cap doesn't apply to habitability claims on attorney's fees, and attorney's fees mean a prevailing party on attorney's fees means that if the tenant makes $1, gets a judgment for $1, that means all his attorney's fees are now recoverable. And if something goes to trial, you're probably looking at over a low 6-figure number at a minimum for attorney's fees. So that's kind of the issue for when it comes to settlement. Sometimes, because oftentimes habitability claims don't actually have physical injury. So these are not claims like a car accident where you broke your arm or you had to go to physical therapy afterwards or your neck hurts. These are claims that are a little more ephemeral. They're a little more vague. You don't know exactly. No one got hurt. So they're claiming, for example, and other than, for example, mold or bed bugs where there sometimes is physical injury, but a lot of times there isn't. There's just a lack of repairs, and they're claiming emotional distress or rental value or something like that. So that's where the damages might not be high, actually. The actual damages a tenant gets, but it's the attorney's fees that can be so high.
Right.
Which is exactly my comment earlier, right? Which is that is essentially what these suits are about.
Exactly.
Is winning that $1.
Yes.
And then I get my $600,000 of attorney fees recoverable from your client. Yeah.
Exactly. And that's where sometimes the settlement comes in because attorney's fees can be very high. In cases where there's no insurance and a landlord has to pay now their own attorney, there's now double issues where you might have to pay your own, and then you could get a judgment against you for attorney's fees for the tenant, which is the last thing anyone would want. So that's where sometimes the settlement comes, because sometimes the actual damages, I've seen cases where out of pocket tenants are claiming $500 in damages, but then they're asking for a mid 5-figure number, but their actual out of pocket's only a few $100s.
Right. This makes sense, Mike. Does this go into your analysis, the carrier's analysis of, look at this defensible position that we have.
Right.
It's airtight. However, there's large attorney fees, right? And, goes to a trial, and you just don't know what's going to happen in front of a jury. What is that analysis?
Well,
like?
you got to look at the facts of the case first. That's where we always start. Look at the facts of the case. They're all a little bit different. Then you look at things like venue. You look at things like, does their past history, Yelp reviews, something as simple as that. How do they look out there on the what's the public reputation of that of that location? Is it a fight that we want to fight? And then we have to think about our insured, our client. Our client could lose through winning, and you alluded to it. Oh, we fought this claim, we took it to trial, we won, sort of, right?
Right.
We got a very low damage amount. There was not much there, but they win, $10,000 or something per client, which, in the grand scheme of things, is not a ton, but that is the tip of the iceberg. That's coverable by us. What's not coverable not by us, by any insurance carrier using an ISO GL form in California. I'm sorry, that's very insurance nerd, but
that's the industry standard,
which is what everybody uses, right?
As if people outside of insurance are listening to this.
The average Joe Rogan listener is not necessarily here, but it's not insurable, right? So what you just said is very important, which is the attorney fees of the plaintiff will be awarded if there's found to be 1% negligent on our client.
Right.
So we know that going in, and we have to think about our insured, because if we have a bigger suit, it's going to be $500,000-$600,000 of plaintiff's attorney fees that are not insurable by us. So we don't think of that as, not our problem. We think of it as we're here to defend. We are the insured. That's what essentially we do. We take over the right and duty to defend a claim. We are the insured. We have to think about them. We're not just thinking about their deductible or how can we get out of it cheapest. There's a lot that goes into it. So that's one of the major things we think about is, could our insured lose by winning here?
Right.
And does it make more sense to fight another day and just essentially make a settlement sort of offer?
Right. And I'm guessing that's where we got right now. So where we are right now in terms of buying or the availability of the insurance is that we've seen over the last, let's say 24, 36 months, some pulling back. So we started off talking about, we had $1 million, it was built into the form, and we started seeing $500,000, $250,000, and then excluded. So I'm guessing the carriers are doing this cost benefit analysis, right? And they're looking at it going, we can't give the coverage, or we have to.
Insurance companies aren't stupid, and we'll lose money for a year, but we're not going to lose money for 5 years. So we figure out a way around it, so to speak. And it might be a lot of things. It's like, you look at California homeowners insurance, right? Some people are just saying, okay, we're going to try to raise. Some people are saying we're not going to do it anymore at all. And some people we're going to non-renew, or we're going to not cover brush fire, whatever. Same sort of thing here. Everybody's looking at this differently. Do we eliminate the coverage altogether? You think it's asbestos. You go back to the 70s, asbestos claims were just killing the insurance industry. And then eventually it got to the point where no one could or would insure it. And it hasn't been insured for 50 years now. And we've all moved on to other things, right? So will habitability become that? Probably, honestly. I think right now, you're right. You're seeing some people sublimit. If you're in the E&S market, you're probably seeing exclusions. You're seeing, big deductibles. It could be a lot of different ways to attack it. If I'm guessing, I don't have any inside knowledge here, but ultimately, why would everybody continue to offer the coverage at some point? It just becomes silly, right? Because you're automatically guaranteeing a loss when you have one.
Now, most operators are good operators in my experience,
Totally
right?
agree.
And so those operators, are the ones that probably are unfairly, being treated in the sense that they're doing everything right, but the availability, the coverage isn't there the way it used to be, and now they're feeling, naked or exposed, without the coverage. That was one of the ideas why I wanted to have both of you on this podcast to talk about how to build a defensible position and do everything right on the front end for those individuals. But I would also say that it's maybe not just the documentation and following a textbook, a course of action, but really maybe with the property manager and the person that's dealing with the tenants, there's an perceived, being aggrieved that triggers maybe a retribution. So maybe it's more than that. Maybe it's there's a communication training that needs to be done, a customer service. You can't please everybody all the time, and you're always going to have people that are angry at you for whatever, but you want to minimize those individuals by just, smiling.
Well, yes, because a lot of the landlord-tenant business tends to be one of those businesses where landlords in particular, managers don't particularly look at their tenants as clients that are paying them. And that's where sometimes, because generally when anyone comes in my office, the first question I always ask is, how did this all start? What happened? And usually someone always has a story as to a fight that started. A landlord went in there and basically, instead of addressing the problem, maybe was arguing, your house is a mess and I can't believe you live like this and this is why it looks like this. And then everyone is upset and that's what starts the fight.
Yeah.
And that's what starts the tenant calling attorneys and saying, hey, this guy basically called me this or called me that and now I'm mad. And I literally didn't do anything. I just wanted something fixed.
And I think that's a very valid point. But the other side of this too is you look at mobile home parks and they have their own version of this called failure to maintain. And we almost always see them after either a new owner has bought it and raised the rents. Something's happened where the rents have gone up or something changed and people get upset. So when you get people mad, whether you're doing the right thing or not, you have to remember there could be consequences. So
right.
Yeah, I'm not saying you can't raise your rent if you own an apartment building, but you have to think about how much what are you gonna get out of what you're asking. What could happen? What are the downsides? What are the upsides? Right? Because we see that as a major trigger.
Right. It's the customer service. Right. That's maybe where to start.
Like I mentioned, I see a lot of them when a new owner comes in. Then everybody they usually have a different tactic that the old owner had, and that's when the suits.
It's going to rub people the wrong. Something's going to rub somebody the wrong way, and then people start talking, and they get together, and then an attorney shows up. Yeah, that happens a lot. Yeah.
Would you also say that just be on the lookout? If you're on site and you hear of an argument that occurred between an employee and a tenant, just don't brush that under the carpet. That could become something larger down the line, right?
It can be, yeah.
It can. And I think I mentioned this earlier a little bit, but like turnover begets these claims. And it's all of a sudden, it's a new person in the property management seat. And maybe this guy or gal was great. And this one's got a little more rough around the edges and rubs people the wrong way. The more turnover you have, the more likely you are to find somebody that's going to make somebody mad. So it doesn't mean hold on to a terrible property manager. There's obviously, an extreme either way, but the most you can do to limit turnover when you have someone decent that's not causing complaints, the better. Keep that person as long as you can.
Yeah. If you could tell, a property owner maybe one or two things, and we've talked about a lot of things, where do you think if you could just give one or two pieces of advice, both of you, what would that one piece of advice be that you'd just say, I want you to leave with this?
Airlift your property out of Los Angeles County and move it out. No, to Fresno. I mean, we
kind of joke about this. We've done a couple of podcasts. We've said that when you get a business
very
in California,
get out of this
it's
venue.
very difficult. It really is. It is.
I don't know if I have anything new or different, but I think the most you can do to document, whether it's a software system, whether it's if it's as simple as text message, you got to be able to give us something to defend you with. The facts of the case determine how we're going to react when we get the lawsuit, and you have to think that way. When they sue me, how's it going to go, and what am I going to have to defend? You have to put that hat on every day you get up as a property owner, as a business person in California, probably anywhere. You got to think, when I get sued, what am I going to use to defend myself?
Right.
And that's, if you think that way, you'll document better and you'll help us help you.
Right. Anthony, do you agree on this? Anything else to add?
I do. And I think sometimes on the landlord side, if everyone sometimes it takes a minute to calm down and remember that someone is living in that unit, and that oftentimes where I see a lot of arguments and fights and lawsuits that stem from that are when, for example, repairs have to be done and all of a sudden a landlord says, well, I don't really care where you're going to stay for the next 3 days. You can't stay here. Well, there has to be, people have to talk to each other. And I think I often tell people 99% of the problems could probably just be addressed if both sides could just talk.
Right.
Not argue, not scream at each other, just talk. Listen to the other, what they're saying. Maybe both sides try to figure something out, because it's shocking how oftentimes the real lawsuit starts because something like that, where, maybe it was some mold damage. It's going to take a few days. Well, then generally there are a lot of local rules now that require a landlord to relocate that person temporarily, but a landlord is trying to find a cheaper alternative and might be a little cruel on the way they say things. And that's what starts a fight. So sometimes just talking to each other as people, actually it helps out a lot. And then documentation of everything.
Yeah, I'm a big believer in emotional intelligence and maybe training on how to diffuse situations, how to maybe not let your emotions, affect the way you're dealing with the human being. Because we're all human beings, and people feel aggrieved very easily if they feel that somebody's not being respectful. And so, that's not just habitability claims, but that's a lot of general liability claims and workers' compensation claims as well, where somebody feels that they just weren't being respected. And I find that the best companies that have the lowest amount of losses generally have people that are active within the organization, that have a cohesive team unit, right, that they're working with, and everybody sort of is working in the same direction for the same purpose.
Yeah.
Right. And so
I really like that answer. I think that's a great answer.
Yeah. Agreed on this one. I appreciate both of you being on the podcast today. This was great. We do have a checklist that we put together at Heffernan, and we'll put a link on the bottom of the podcast. And if you would like a copy, just let me know. Mike, Anthony, appreciate it.
Thank you.
Thanks for having us.
Thank you.